My landlord kept my $1,500 security deposit, laughed in my face, and said the same 6 words he'd said to every tenant before me. Sue me. Nobody ever sues me. He'd been collecting deposits from that building for over a decade, 30 units, every move out, every time. And he was right about one thing. Nobody ever had. What Vic didn't know was that the quiet nurse in 4B reads everything. Charts, contracts, fine print, and one particular page of state law that he, a professional landlord, had apparently never opened in his life. 8 months later, I sat in the back row of small claims court and watched him lose to his own tenants 9 times before lunch. But let me start from the beginning. I'll go by Maya. I'm 34 and I'm an emergency room nurse, which matters for exactly one reason. Nurses chart everything. It gets drilled into you from day one. If it isn't documented, it didn't happen. You chart the dose, the time, the response, the refusal. You document like your license depends on it, because it does. Hold on to that habit. It's the whole story. For 4 years, I rented apartment 4B at a 30-unit brick building I'll call Marlowe Court. The landlord, I'll call him Vic, owned the place outright and ran it like a toll booth. Rent in cash, if you had it. Repairs when he felt like it. And a security deposit of $1,500, which he collected from every tenant with the warmth of a man who already considered it his. Last spring, my sister and I decided to get a place together across town. I gave my 60 days notice by the book. And that's when I joined a club I didn't know existed. I did the full move-out ritual, scrubbed the oven, patched the nail holes, steam cleaned the carpet myself. And then, habit of the job, parole, I filmed a slow walkthrough of the empty apartment on my phone, every wall, every corner, time-stamped, narrated, like a chart note. Vic met me at the door, took the keys without looking up, and said the deposit would come within 30 days. It's the process. On day 31, I got a letter. Not a check, a letter. An itemized masterpiece of fiction. Full repaint, $600. Carpet remediation, $700. Deep cleaning, $300. Total, $1,600. Which meant, and I need you to sit with this the way I had to, after keeping my entire deposit, Vic's letter said I owed him $100. He kept my money and sent me a bill. The audacity was almost impressive. Almost, I called him. I was still polite at this point. ER nurses are professionally unflappable. I asked about the repaint since I'd left the walls perfect. And Vic laughed, actually laughed. That's the paint tax, sweetheart. Everybody pays the paint tax. And then, before I could answer, the dare. You want to fight it? Sue me. Lawyers cost more than $1,500. Nobody, ever, sues. Here's what Vic didn't know. The tenants of Marlowe Court had a group chat started years ago for package deliveries and lost cats. And Vic was not in it. That night, I typed one question into it. Has anyone here ever actually gotten a deposit back? 60 messages in an hour. Every single move out, going back years. Same letter, same paint tax, same $700 carpet remediation. Some people billed extra, exactly like me, because apparently the extra 100 was Vic's signature flourish. Mrs. Okafor, the retired teacher in 2A whose husband had passed, lost hers. The young couple who'd left for a job in another state, too far away to fight, lost theirs. I did rough math on the back of a takeout menu. 30 units, a decade of turnover, 1,500 a head, somewhere north of $45,000. This wasn't a cheap landlord. This was a business model. And I'll be honest with you, I almost let it go. $1,500 against lawyers and court dates and months of hassle. That's the exact math Vic was counting on. That's the math that had worked 30 times in a row. Then, on a night shift, a week later, standing over a chart at 3 a.m, the sentence that runs my whole professional life floated up. If it isn't documented, it didn't happen. And I froze. Because Vic's entire scheme, every fake charge, every paint tax, was documented, dated, itemized, signed by him. He'd been mailing the evidence to his own victims for 10 years. I went home after that shift and did the one thing that, as far as I could tell, no tenant of Marlowe Court had ever done. I read our state's Landlord-Tenant Act, all of it. And you guys, it was beautiful. Let me walk you through what Vic, career landlord, had never bothered to read. Because write this down, seriously, this part is real life. First, in our state, a security deposit never stops being the tenant's money. The landlord has to hold it in a separate escrow account and tell you where, in writing. Vic had never disclosed an account to anyone ever because there wasn't one. Our deposits had been living in Vic's pocket. Second, deductions have to be itemized with receipts within the deadline. And here's the sentence that made me laugh out loud alone in my kitchen. Normal wear and tear cannot be deducted repainting between tenants. Wear and tear, carpets aging, wear and tear. Vic's paint tax wasn't just rude. It was, line by line, exactly the thing the statute was written to punish. And third, the part Vic really should have read. Withholding a deposit in bad faith doesn't cost a landlord the deposit. It costs him triple plus court costs. And his famous line, lawyers cost more than $1,500. Backwards, completely backwards. Small claims, court exists precisely for this. $50 filing fee. No lawyer needed. No lawyer even allowed to be necessary. The forms are designed for regular people. Vic's entire empire rested on a bluff that dissolved on contact with one afternoon of reading. Now, quick question, and I actually want to know, so tell me in the comments right now. At this point, do you file just yours and walk away clean? Because that was plan A. But I'm a triage nurse. When I see one patient with symptoms, I don't wonder about that patient. I wonder who else in the waiting room has it. So, instead of filing quietly, I built a kit, the statute section highlighted, the link to the small claims form, a one-page template, an evidence checklist, your lease, Vic's deduction letter, photos if you had them. And I posted the whole thing to the group chat with one line. He owes most of us $4,500, not $15. Here's the recipe. Then Mrs. Okafor, bless that woman, forwarded it to every former tenant she'd stayed in touch with, which, since she'd lived there longest and baked for everyone, was basically all of them. I didn't organize a rebellion. I posted a PDF. The rebellion organized itself. The filings went in like triage waves. Mine first. Then 4 more the same week. Then 11. The court clerk, seeing the same defendant's name over and over, clustered the hearings. Which is how Vic ended up facing the same judge, holding 30 copies of the same fraudulent letter, morning after morning. My hearing took 11 minutes. Vic smirked through the first 5, right up until I played the time-stamped walkthrough video, and handed the judge his letter. The judge asked Vic one question. "Where are your receipts for these $1,600 in repairs?" There were no receipts. There had never in 10 years been a single receipt. Bad faith found. Triple damages awarded. $4,500 plus my $50 filing fee plus interest. Vic paid 30 times over for the $100 flourish he just couldn't resist putting on my bill. And then the next case was called. Same letter. Then the next. Same letter. By the third week, Vic had stopped smirking and hired the lawyer he'd sworn nobody could afford to lose $4,500 at a time with counsel at several hundred an hour. One tenant even produced a text where Vic had written his catchphrase down, "Nobody ever sues me." And the judge read it aloud, into the record with no expression whatsoever. That's the thing about a dare. It's evidence with confidence. When the dust settled, the judgments, trebled, stacked, plus costs, came to well over $100,000, owed to the very people whose $1,500 he'd never been willing to give back. Vic didn't have it. The deposits, remember, had never been sitting in an escrow account. They'd been spent. So Vic did the only thing left. He sold Marlowe Court. The new owners were a regional management company, and their first letter to every current tenant said the quiet part in writing. All deposits now held in escrow, statement enclosed, interest accruing, as the law requires. Mrs. Okafor's judgment was the first one paid. Me? I'd already moved. But I drove back one last time, walked into that lobby, and pinned a single page to the community notice board, the statute, with the triple damages paragraph highlighted in gold. Well, yellow, but let me have this. Underneath it, I wrote 4 words. Chart everything. 4B. So tell me, would you have filed over $1,500, or was it never really about the money? Tell me in the comments. And subscribe, because next time on the Karma Archive, a man applying for his first mortgage discovered his credit was ruined by cards he never opened, and the fraud had started the year he turned 16 in his mother's handwriting.